Hello and welcome to a meeting of the Legal Affairs Committee of the California Citizens Redistricting Commission. I'm Russell Yee, the rotating chair for this committee. Director Hernandez, could you call the roll, please?
Yes. Commissioner Sadwani. Push it again. There you go. Now.
Very much here.
Commissioner Toledo.
Here.
And Commissioner Yee.
Here.
You have a quorum, Chair.
Thank you, Director. Any general announcements other than to say, Commissioner Sadwani, I hope you're enjoying your first look at the office there in Sacramento.
Yes, very much. It's so exciting to be here. I feel like we have been serving on the commission for nearly a year, so very excited to be here, even though we're still masked. Very, very happy to be here.
And I myself am actually zooming in from Delaware, my first visit here. Okay, shall we go ahead and open with public comment? And if we could have instructions, Katie?
Yes, Chair. In order to maximize transparency and public participation in our process, the commissioners will be taking public comment by phone. To call in, dial the telephone number provided on the live stream feed. It is 877-853-5247. When prompted to enter the meeting ID number provided on the live stream feed, it is 988-6703-5174 for this meeting. When prompted to enter a participant ID, simply press the pound key. Once you have dialed in, you'll be placed in a queue. To indicate you wish to comment, please press star 9. This will raise your hand for the moderator. When it is your turn to speak, you will hear a message that says the host would like you to talk and to press star 6 to speak. If you would like to give your name, please state and spell it for the record. You are not required to provide your name to give public comment. Please make sure to mute your computer or live stream audio to prevent any feedback or distortion during your call. Once you are waiting in the queue, be alert for when it is your turn to speak, and again, please turn down the live stream volume. And we do not have anyone in the queue at this time, Chair.
Thank you, Katie. I'll go ahead with chair updates while we wait a minute for any callers. I will do my best to end this meeting in time for at least a small break before the 4 o'clock commission meeting. The only other update is that, as you've all heard, the VRA Council contract has finally been approved and put in place. And so we will have our first VRA strategy meeting on June 30th, 1 to 4 p.m., again, right before a commission meeting. And we'll have our VRA Council there and line drawers there. And so that'll be our first meeting to get that whole process started.
Chair, the instructions are complete on the stream.
Okay, just wait another few seconds.
You know, perhaps as we're waiting, just in terms of general announcements, I did want to just share with you all, not as a part of CRC business, but certainly we have previously discussed the California Voting Rights Act and the case from the city of Santa Monica that's currently before the California Supreme Court. And last week, we filed a scholar's amicus brief in that case. And so I did want to just let folks know that I did that in my personal capacity, and that case has no direct bearing on the work of our commission.
Thank you, Commissioner Sadwani. Okay, there being no callers, let's go ahead with item 4, review of litigation counsel contracts. And those are 2 in number. They are included in the meeting handouts. 1 contract for Gibson Dunn, 1 contract for Strumwasser Wucher. And kudos to Commissioner Toledo and staff for all your hard work getting those big contracts all together. I know that's a lot of work. And so let's go ahead and open discussion on the contracts. I can start by mentioning a few items that I've already discussed with counsel, our chief counsel. There is an additional matter, which actually in a moment I'll have Chief Counsel Payne describe, adding an item to describe the provisions for working together should the two councils need to cooperate in some joint activity or with any other outside, entity that we engage in a matter. Also mentioning that dollar amounts, actually this probably would bear some discussion. The contracts will have to include a separate document that specifies the dollar amounts that the contracts are for. So there's a certain amount budgeted, and we actually need to divvy up that budget between the two firms. And we have a proposal for that we'll need to discuss. Let's see, the only other item was conflicts of interest. As you know, the provisions for that are fairly intricate. They're basically the same as the RFI provisions, and just want to check to make sure everyone is comfortable with those. So Chief Counsel Payne, why don't we start with you and a description of the item that you're going to add.
Sure. Thank you, Chair. I actually wanted to highlight it for all of you because some of you may have that question. If you pull up the contract, it is in item 1J. I added that based on Commissioner Sadwani's recommendation at a previous Legal Affairs Committee meeting. And it says the contractor shall work collaboratively and cooperatively with all CRC designated or contracted counsel should the need arise to efficiently assist the CRC in its litigation efforts. And that was my attempt to get at Commissioner Sadwani's ask about making sure that both Gibson and Dunn and Scrum Master Butcher work together and work with CRC. And depending upon if they're counsel at the same time on the same matter, or if they are only one is on and one is not. Nevertheless, both are CRC designated contractors, and we will be working with them. And so this contract is this provision is in both contracts. So when they sign this, they are agreeing to work collaboratively and cooperatively, both the CRC and anybody else that we contract with. Everybody knows we would be contracting with from Master Butcher and Gibson and Dunn. To the second point of the what Chair you mentioned, which is about the split. This is on the separate sort of cover form that needs to be submitted to the Department of General Services when we allocate how much the contract is for, and so we do need to at least provide. And this can change. We can always amend and change this amount, but initially we need to provide a number so that the Department of General Services understands how much, and frankly the contractor understands how much well each of these contracts will go for. And so we do need to designate, and as you mentioned, this is a little bit of a policy discussion for the committee's part. As to how much they want to allocate that. So much to Scrum Master Butcher, so much to Gibson and Dunn. Again, this all predicates, this could change the circumstances, capacity, nature of the litigation, all of that may require us to go back in, which would be fine to do that, reach back out and make those changes. But again, this is not changing substantively the contract, this is just changing the amount awarded under a different contract based on the.
Thank you. Well, so why don't we take those in order? Let's take a look at that clause J, and any discussion on that? I'm wondering, so let's say there is a matter that we decide we'll need both firms to collaborate on. So our chief counsel directs outside counsel. And so would there be any need to designate a lead counsel in such a matter? Do we need to say anything about that? If we have both, engaged on a matter, does one of them need to be a lead counsel, or is that just something that might happen, but it would just be up to our chief counsel to direct.
I would think that the chief counsel would look at the situation, the claim at hand, and determine which resource would be best to use in that particular case, and then determine how to allocate the vendor time, whether it's one of the two litigation firms or potentially the VRA under the VRA contract as well. So I would think the chief counsel, because the chief counsel ultimately is not just managing the work; he's also managing the budget for this effort.
Right. Okay, well, since this clause was drafted by Chief Counsel Payne, I'm going to assume he's happy with it. So that's fine as long as he feels that covers all the contingencies. Okay, for the second matter, so the question is,
Commissioner, I'm just curious. Do you think we should be a little bit more specific and actually have a lead for each? Are you suggesting we be a little bit more specific in that clause, or?
Well, I'm just thinking if there is a matter in which one of them we decide that one of them should play the role of the lead. I mean, that's kind of implied in collaboratively and cooperatively. I don't know. Maybe that's generally enough to cover all the possibilities.
But I guess in terms of, I can see your point in terms of just trying to reduce confusion between the two firms and miscommunication by designating a firm to lead needs claim. I don't know if you have any thoughts about that, Director Payne or Chief Counsel Payne.
What you could do is I could put something in the contract that say the chief counsel.
Anthony, we're having a hard time hearing you. Is there any way you can adjust your microphone, please?
Is it?
That's it right there.
Is that any better?
That's much better.
Okay. Any better now?
Yeah, that's a little better.
Yes, you're good.
Okay, thank you. All right. What I could do is add in the contract.
Oh, no.
Nope, didn't quite work.
How about now?
Yes, better.
Okay. Might have to.
Are you using your headset mic, Anthony?
I believe I am.
Okay. Can you hold that headset mic up a little bit? Just hold the mic up.
Well, they're just, I'm sorry, they're headphones.
Gotcha.
Headset.
Yeah, gotcha.
Is this okay?
Yeah, we can hear you now when you speak that close. Yeah.
I'll keep doing this for a while. What I could do is add in reference to in the contract about about CRC designated primary on a particular matter. And that would leave the flexibility to, depending upon the particular issue, there would be a designee. And of course, regardless of that designation, both parties, all three, would be working collaboratively. With that, how about if I added something along those lines to Jay?
Yeah, maybe the Chief Counsel may at its discretion designate a primary counsel on a matter, because you may or you may not. You may just have them both helping with different bits of something. So.
Yeah, I think that's right, because I'm trying to look and find where within this contract we identify the fact that our chief counsel will be able to designate one or the other law firms to serve either as primary or secondary. And maybe it's hidden in here somewhere a little bit deeper that I hadn't seen. And if that's the case, please do point me towards that. But I do think having some specific language that we retain the right through our chief counsel to identify who would serve in a primary role if we needed to have such a primary role. I don't know how we want to structure that language, but I think making sure that it's clear. Each law firm may not necessarily take on every litigation claim that could come against the commission would be important.
And that certainly was the spirit. I believe we have a provision in there that the chief counsel would look at every claim and make a determination as to which firm to assign that claim to. I just can't remember where it is in the contract.
By the way, Commissioner Toledo, are these two contracts identical except for the billing schedule or the hourly billing schedule?
My understanding is that they're pretty much identical.
That's my understanding as well. Yeah.
So Chief Counsel Payne, perhaps could you, if you happen to know, could you direct us to the portion of the contract that gives you the explicit power to designate which matters, if any, will be taken up by each firm?
I think it's section page 1, section E. Litigation counsel will designate a senior attorney to have primary responsibility for. Oh no, that's the firm actually having it. But the assignment of the senior attorney to the matter requires prior discussion and agreement by the commission's legal affairs committee or the chief counsel. Is the last line there?
There it is.
So it's that last line.
Yeah. And in fact, that covers a situation where you may have both firms, because one will be designated as a senior attorney.
I mean, I can see us moving the last line to the top, where it says the assignment of the senior, or it may not make, or just shifting it around a little bit. But I think it's fine the way it is. I mean, you just have to.
Okay.
Okay, so I think where we're at is we're just leaving it to Chief Counsel Payne to perhaps add a bit of language to item J, just to clarify that Chief Counsel may designate one firm as primary in a matter. Otherwise, no other changes.
I guess one thing we might want to think about, it says the assignment of the senior attorney to the matter requires prior discussion and agreement. Might we want to make that a little bit broader than just the senior attorney?
Commissioner Toledo, you're talking about E?
Yeah, section This is the it's referring to litigation counsel. Litigation counsel will designate a senior attorney. So the firm will designate a senior attorney. And then that assignment of the senior attorney to the matter requires discussion prior discussion and agreement by the commission's legal affairs committee or chief counsel. I'm just wondering if perhaps we want to make that a little bit broader than just the senior attorney. Is it, or if you think that's sufficient?
I'm fine whichever you prefer. My guess is, and I'm reading a little bit into it, but my guess is that perhaps there was an interest, either maybe on the committee's part, I don't know, about it being designated to somebody who was, pretty knowledgeable at the firm, and so having that, I guess, comfort with that. that said, I would certainly be coordinating with whoever was designated and making sure that, that the issues are still being addressed. So, and if I needed to, I could certainly reach out to a more senior attorney if that's ended up being the case. So I think we could do it either way.
Okay. I think this is fine. I was just curious. Thank you.
So among the firm's proposed attorneys, then it's our choice, not their choice, who gets assigned to a matter. Is that the understanding?
Mm-hmm.
Okay.
I'm looking. I'm sorry. I'm a little.
Sure.
I'm still dealing with the audio, but is this
Sure.
better now?
This is
You can
much
all hear
better.
me.
Yes,
yes,
Okay. All right.
Yeah.
I think thank you, Katie. Okay. So let me see if I can find where in the contract we're discussing about if we decide or the firm decides, who is designated.
Well, I think we're looking under 1E. Is that correct?
Yeah, that's correct.
Yes. So I think the issue is this language around a senior attorney is somewhat vague, at least to me, especially knowing that the firms themselves have their own designation for their attorneys. Who would that senior attorney be, for example, at Strumwasser Wucher or at Gibson Dunn? It's not clear to me who that would be.
And actually, as I look at 1E, it starts off litigation counsel will designate a senior attorney. So
Right.
that starts off by giving them the right
The
to
decision.
choose. Yeah.
So I could change that to the CRC or the chief counsel in collaboration with the contractor will decide or agree on, which attorneys are going to be working on the case. We could do it that way.
Sure.
Does that
and
strike a
maybe-
better balance?
Yeah, because that combines the first and the last sentences then.
And I'm almost thinking that we should probably start off with chief counsel will determine which firm, which of the litigation counsels will be assigned to the case before we get to the designation of who was going to serve as the senior attorney.
So sort of a two-step. First the firm, then the actual attorney or attorneys.
Just to be very clear with the
Yeah.
firms, right? We get to determine who's going to be representing us, and we also get to work with you on figuring out who the senior attorney is going to be on the case.
Maybe lead attorney would be better than just yeah. Commissioner Sobhani, yeah.
Yeah, I agree with that. I also think that is a very budget conscious move as well, recognizing that some of their more senior attorneys and partners certainly cost more in their hourly than some of the other folks on their teams.
Okay, I can make that change to E.
Okay. Any other changes? I'm thinking to give Chief Counsel Payne time to make these revisions and post a new version. I'm thinking to have this brought to the full commission on the 25th for approval, assuming that we're all good with everything up to then. At the meeting for the 25th, the agenda item for this only mentions discussion of the contracts. I don't think that limits us from being able to approve them as well, though. Is that correct?
That is correct, because we do also say that any item up for discussion, we may end up taking action on them as well.
Okay, very good.
If that's what's needed.
Yeah. So does that sound good to everyone? Wait till the 25th to actually seek approval.
I think that makes sense.
And we're not in a great rush. So
I think the next area of discussion was the allocation, the budget allocation to each firms. Is that correct, or was there another provision you wanted to?
That's correct.
Okay.
Yeah, allocation.
So I think Anthony has a proposal on how to allocate the funding, which made a lot of sense to me.
Please go
Thank you,
ahead.
Commissioner. Yeah, thank you. So currently we would recommend a 70-30 split according to 70% of the total contract amount go to Stromwasser-Witcher and 30% go to Gibson and Dunn. Based on the 4.297 allotment, that would be, believe 3,007,900 would be going to Stromwasser-Witcher and 1,289,100 would be going to Gibson Dunn. And again, that's subject to change depending upon the circumstances that arise. But this far out, at least right now, we could divide things essentially a 70-30 split. But again, that's just a quick recommendation. It's up to all of you.
Sure. Just a question for Alvaro or whoever is able to answer the question. What would be the process of reallocating the funds? So if we decided that we needed more of Gibson Dunn's time, or that the VRA spend we didn't quite finish the VRA spend, and there's significant amount of money there to be spent, and want to use some of the want to use additional funds for Gibson Dunn, what would be the process by which we would reallocate the funds?
I may need to get back to you on how we reallocate the funds. Just for your reference, the funds that are used for this particular litigation contract are the ones that have been allocated for post-MAPS litigation or activities. And so there may be some flexibility. I don't know if we're hamstrung to the specific amounts that we are allocating at this point or not. So I'll check with Raul tomorrow and get back to you all.
I think that'd be helpful. I'm just curious, would there be a way of moving funds, because this is a contractual relationship, although we do say that the firms would be able to bill up to the amount that, up to the cap that we are setting, but I'm just curious what the process would be to do an amendment to change the caps, essentially.
So I know that in the past
that we need to do that. I mean, at this point, it's really early in the process, but we just need to know what that process is, given that any contractual change tends to take a while to do, right? So we'd have to think about it ahead of time and be able to process the appropriate documentation and go through that process with the appropriate state agencies.
I know that in the past, Raul has included language to give us some flexibility to adjust or amend, not adjust, but amend the contracts should they need to be amended. So again, I'll touch base with him tomorrow and see if that language can be included here, and we'll run it through Chief Counsel to make sure that he's aware of it, and then we'll share it with all of you as well.
Very good. And, it's a question I'm sure will come up on the 25th. So as long as we're ready by then. The 70-30 split was in recognition of two things. Basically, one, that Stromwasser-Witcher is also our VRA counsel, and so would be intimately involved in VRA matters and working closely with us over time more. So would possibly be in a position to represent us in more matters post-MAPS. Also in recognition of the differential billing rates, and Stromwasser-Witcher gets us more bang for the buck. So more bucks on that side of the balance. So let's think. Do we actually need a motion to approve this split, or?
I would recommend that we do a. If we're recommending this that the commission approve it at some point, and if it's approved out of committee, I'd recommend that we at least have something to reflect the committee's will on this.
Okay. Any further discussion on the 70-30 proposal?
I mean, just in terms of the rates, I have been in contact with Gibson Dunn around them, and the converse at this point, there are, the question that I posed at this point is what are the rates that other public entities are paying for their services, and are we comparable to those? The response back was that they have two new public entities that they're representing on redistricting matters, state redistricting matters, and that both have accepted their publicly available standard rates.
Wow.
That, of course, is and there may be good reason for that. The potential risk, the liability to municipalities in losing these claims and defending claims under the state, under these state claims is quite high, and so there's significant liability and potential. So municipalities may be more willing to pay these rates than others might, because they are, as we've noticed, these are very high rates.
I'm thinking we could perhaps entertain a motion to approve the contract with the suggested amendments, as well as the 70-30 split together.
I would be happy to make such a motion.
Okay, I'll be happy to second it.
And I support it, so that's the three of us.
What a team.
Yeah, but we need to get public comment.
We'll go ahead and take public comment, and the public may follow the instructions on the live stream page. And any further discussion while we wait? So seeking to approve the contracts with suggested amendments and the 70-30 contract split for recommendation to the full commission. Okay, if there are no public comments, I believe we can go ahead to the vote.
I think we still need to open the lines.
Yes, there's no one in the queue. The instructions were posted online, and the chair did make that notice. So, thank you.
This is our new
But
practice.
if someone is listening on by telephone, they wouldn't know if it were posted.
This is true. Are we required to read the instructions because of that?
We did read the instructions at the beginning of the meeting.
So my understanding is that we may depend on that, as well as the instructions in the agenda. So I believe we can go forward with the vote.
Yes, yes.
Let's do so then.
Okay, once again, I'll read the motion. Motion to approve contract with amendments with the 70, that's for Stromwasser, and 30 for Gibson Dunn, split for recommendation to the full commission. Is that correct, Commissioner Sadwani?
Yes, that is correct.
Thank you. Motion seconded by Commissioner Yee. And we'll begin the vote. Commissioner Sadwani,
Yes.
Commissioner Toledo,
Yes.
and Commissioner Yee.
Yes.
The motion passes. Thank you.
Thank you, everyone, for all the good work. Okay, moving along to the discussion of future agenda items. Thinking of the meeting on the 30th, which is a public meeting. It'll be our first meeting with the VRA Council and line drawer. A couple of outstanding questions. First question has to do with which CRC entity will be working with the line drawer. I'm sorry, we'll be working with our chief counsel, interacting with our VRA council. Would it be the Legal Affairs Committee, this committee, or will it be the VRA subcommittee, which is Commissioner Sadwani and I? A bit of a trade-off. If it's the VRA subcommittee, then we can be a bit more agile since we do not need notice meetings for that subcommittee. If it's the Legal Affairs Committee, then of course all meetings are public and therefore we have that additional level of public communication. So any thoughts?
We've also thought about expanding this committee so that 2 members can because we had 5 members and 2 member committees members would be able to have meetings without having a bag of king issue.
A committee subcommittee.
A subcommittee of a committee. I mean, that's also another thought. I mean, I'm just throwing that out there. And at this point, I'm not sure if there how many people on the commission would even be willing to add another committee to their schedule. So,
and that wouldn't actually change the nature of the question, because then that subcommittee would be meeting not in public also, just like the VRA subcommittee would be. So
my sense is that as we're thinking about strategizing for our VRA compliance plan, it's perfectly fine to do that within a 2-person subcommittee. It's only advisory in nature, and whatever the plan is would come back, I would assume, both to the Legal Affairs Committee as well as the full commission. So I think my preference would be that, because I think then the lag time from one meeting to the next is not quite so long. At least some conversations can happen, some work can get done from one meeting to the next and then be reported back. But certainly, I'm happy to take the recommendation of this full committee or the full commission as well.
I'm thinking that the VRA subcommittee, being able to be more agile would be a big plus. And if any matters were so weighty or controversial that, they needed more advice, it could certainly be brought to this committee or to the full commission, of course. But, the ordinary work can proceed more expeditiously with just the VRA subcommittee.
I'm curious how the 2010 commission handled the VRA the communication with VRA council and the VRA work. Marion, do you remember?
I believe that they did designate a subcommittee of their Legal Affairs Committee, which consisted of attorneys to work with the law firms on day-to-day matters.
And were those meetings done in public, or were they done?
No, it was done just with 2 members, so it was not done in public.
So I think that's good.
And as it happens that, with Commissioner Sadwani and I are on the VRA subcommittee, that's effectively what we have anyway. So
I think that makes sense to me.
Okay. Let's think. Do we need anything more than consensus on that?
I don't think we need it from our committee, but might the full commission need to expand the scope of the VRA committee to because if I remember correctly, the VRA committee scope was really the charge was around getting the contract right, hiring a VRA or putting the VRA contract together. And I'm not remembering if it was broader than that, but if it is, then I don't think there's any other action that would be needed.
I believe it was broader. Certainly, we had talked about VRA compliance, broadly speaking. And Commissioner Yee and I had been working on multiple trainings. We had talked at one point about putting together a handbook. I forget, what were we calling it, Commissioner Yee?
Briefing book.
Yes, a briefing book. That never happened because we thought perhaps a new Voting Rights Act law would pass, and then it doesn't look likely. But so certainly, I think the scope was broader than just the contracting component of it. And in fact, when it came to the contracting, it was when it was the recommendation of the VRA subcommittee to create the Legal Affairs Committee for the purposes of contracting. But I agree. I think we should most certainly bring it up with the full commission and make sure that we have the consent of the full commission to advance that work.
Very good. So we can bring that up on the.
I just couldn't remember the scope of the committee, but yes.
Yeah, I think it was
I'm
all.
remembering it now. Thank you.
Yeah. Very good. We can bring that up on the 25th. When I'll be chair, actually, as it happens.
And you get to decide, actually.
A second matter with the meeting on the 30th coming up and discussing the agenda for that. We have Chief Counsel Payne as liaison to Stromwasser-Witcher, our VRA counsel. So he'll be directing them in preparation for that meeting. In terms of our line drawer, the question is who will direct them and help them prepare for the meeting on the 30th. And would that be myself as chair of this committee or someone else? I really just hadn't thought through that.
I think it makes sense for Commissioner Sadwani, given that she was on the committee that or Commissioner Yee. Just I don't think it makes sense for me because I haven't had as much communication with that part of the work.
Perhaps as chair of this committee, I can just designate Commissioner Sadwani to work with our line drawer in preparation for the meeting on the 30th and going forward with all VRA related line drawing matters.
Sure, I would be happy to do that. And I think I can just say we have a standing weekly meeting with the line drawers, which Alvaro, Anthony, and other, and of course Commissioner Anderson are a part of as well. So happy to bring that up in that meeting and coordinate with them. As it pertains to the meeting on the 30th, I did want to just provide additional direction to Chief Counsel Payne regarding some of our expectations. I know previously we've discussed that we would like to see a plan, something in writing, of what our next steps and path would be that the VRA Council is recommending for the Commission. I think it would be very helpful. I mean, I think we have about 2 weeks before that meeting, so it would be very helpful if the Stromwasser-Witcher-Becker team could plan to bring a draft of such a plan to that meeting, something that we can read in advance and respond to. I don't want to waste these 2 weeks that we now have before us. I know they, of course, given our agenda, couldn't be here with us today, but I do want to make sure that some work is happening and we're making progress towards our VRA compliance responsibilities.
I will make sure I touch base with them on that in advance.
Thank
I know
you.
our line drawers had already had some thoughts on how to proceed in this matter. It is VRA Council under Chief Counsel Payne's direction that will lead in strategizing. However, is that the thought? I'm just trying to clarify what the role then between the line drawer and VRA Council is as we work on this.
I think my initial thought is that I would certainly be liaising with Stromwasser-Witcher to make sure that what they're working on coincides with what we need the line drawers to also be working on. But I could probably work in collaboration with Commissioner Sadwani on that as well.
Yeah, and I do think making sure that the legal side as well as the line drawer side, that they have a good working relationship. I certainly remember famously Mr. Becker mentioning a prior knowledge of Karen McDonald. So certainly making sure that they are working collaboratively in this process, because I think the two most certainly need to work hand in hand. There will need to be that legal analysis, but it ultimately has to result in line drawing.
Very good. So, Chief Counsel Payne will work with Scrum Master Witcher preparing for the 30th. Commissioner Sadwani will work with the line drawer, and one of the goals of the 30th will be to clarify with everyone in conversation what the lines of direction are and what the workflow will be going forward. Okay, the only other matter is part of our VRA. Actually, this is not in the. Is it in the contract? We've been discussing earlier how the VRA Council would also be responsible for providing VRA training for the commission, and now I realize that's actually not specified. I'm sorry, it is. Is it specified in the contract? I can't recall. I recall now. I'm getting for a moment. I was getting the litigation counsel contract mixed up. The VRA Council contract.
The VRA Council contract does specify that that they would be able to provide us with preventative counsel on issues. So this would qualify as that.
Very good. So the question is when to ask Chief Counsel Payne to direct them to begin such training. Should that be like pretty soon, or it could be agendized for the 30th if we decide that right now?
Well, I think we may want to have a conversation about what we want to see at that training too, and give some guidance to Chief Counsel Payne in terms of what we want to see in terms of that strategic planning session, and what our goals are going to be, and that'll help him in working with the firm and other consultants in getting us the outcome we want to achieve.
Right. So the next opportunity after that would be the July 7th full commission meeting. We could go ahead and agendize that, and optimistically.
So I'm just thinking that maybe it's the VRA subcommittee that we can ask the VRA subcommittee to come up with the goals for that training and work with the Chief Counsel, because it is VRA, right? So VRA Council would work on the goals, give that to Commissioner or to Chief Counsel Payne, and then and have and bring that back to the Legal Affairs Committee. Or wherever we want to.
If I may, I'd like to actually recommend 2 trainings.
Okay.
I think that there's a need for, and you can correct me if I'm wrong, but I think that there might be a need for a short, fairly general training on what kinds of litigation are brought against redistricting maps. VRA is one of them, but I think there are others as well, right? Based on procedure and other kinds of litigation that could be brought. There could be national issues also. For example, whether an independent commission has the right to redistrict on congressional lines, which is something that we've heard about. We heard a lot throughout the interview process of the various litigation firms that we interviewed about potential litigation. I think it would be really helpful to have some time, perhaps on June 30th, for the full commission to hear that as well, to understand more about what kinds of litigation might be brought, what kinds of things we might want to be considering and thinking about during this time period as we move towards that phase in which we anticipate litigation. I think if we can agendize for June 30th for a short kind of training of that sort, it would also give the full commission an opportunity to see the litigation team, the Stromwasser-Wucher team. We're the only ones that had a chance to interact with them. And I do think it's important that the full commission does have some time, have some face time, if you will, with the team. I think it can be short, in terms of the, for billing purposes. We don't need to have it continue on forever. But having a little bit of time on June 30th would be great. And then, the VRA subcommittee could work on the parameters of a VRA training for the full commission moving forward. And that might be in conjunction perhaps with discussion of a full VRA plan if we have it, right, for the July 7th meeting.
Right. So a short training on the 30th, that would be following the long strategy meeting. So we can go ahead. Perhaps we'll go ahead and agendize time both on the 30th and on the 7th for we can say just VRA training and fill in the details later.
Yeah, VRA and litigation training, something like that.
Yeah. Okay.
What time is our meeting going to start? June 30th?
It's in 5 minutes.
Oh, no. And June 30th?
Oh, it's 1 to 4.
1 to 4. Okay, thank you.
And then the full commission 4 to 8. Okay, would like to take closing public comment. And the instructions again are on the live stream landing page as well as on the agenda. If anyone has any closing comments for the Legal Affairs Committee of the California Citizens Redistricting Commission. In a few minutes at 4, we'll have a meeting of the full commission begin.
And there is no one in the queue at this time, Chair.
Thank you, Katie. Just let us know when the feed catches up.
Will do. And the feed is caught up, Chair.
Thank you, Katie. Okay, anything else? Anybody? Hey, I got you 3 minutes. Okay, there being no further business, this meeting of the Legal Affairs Committee is adjourned.